Hello friends and welcome. We are here to discuss a very important subject related to offences, and in today's discourse we shall discuss offences against property. Before we go deep into the subject matter, first of all we need to understand that offences against property find a prominent place in the Penal Code. Offences against property is the second longest chapter consisting of 85 sections. The basic element common to the offences under this chapter is dishonesty, which the code describes as the intention of causing wrongful gain to one person and wrongful loss to another, but the manner in which dishonesty is exercised differs in different cases. Hence, the offences have been classified into various categories for a clear understanding of the different concepts involved therein. In view of the wide range of illegal deprivation of property, the Penal Code describes it under the following subheads. Number 1, theft, sections 378 to 382. Number 2, extortion, sections 383 to 389. And number 3, robbery and dacoity, sections 390 to 402. The Indian Penal Code defines the offences of theft under section 378. The section reads as, whoever intending to take dishonestly and movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. In order to understand it clearly, here are some explanations. Explanation 1. A thing, so long as it's attached to the earth, not being movable property, is not the subject of theft, but it becomes capable of being the subject of theft as soon as it is severed from the earth. Explanation 2. A moving effected by the same act which affects the severance may be a theft. Explanation 3. A person is said to cause a thing to move by removing an obstacle which prevented it from moving or by separating it from any other thing, as well as by actually moving it. Explanation 4. A person who by any means causes an animal to move is said to move that animal and to move everything which, in consequence of the motion so caused, is moved by that animal. Explanation 5. The consent mentioned in the definition may he express or implied and may be given either by the person in possession or by any person having for that purpose authority, either express or implied. In order to understand this, let's take a few illustrations. For example, A cuts down a tree on Z's ground with the intention of dishonestly taking the tree out of Z's possession without Z's consent. Here, as soon as A has severed the tree in order to such taking, he has committed theft. Here's another illustration. A puts a bait for dogs in his pocket and thus induces Z's dog to follow it. Here, if A's intention be dishonestly to take the dog out of Z's possession without Z's consent, A has committed theft as soon as Z's dog has begun to follow A. Here, let's try to understand the meaning of theft. This section, that is section 378, defines the offence of theft and section 379 prescribes punishment for theft. Theft as defined in section 378 is the dishonest removal of movable property out of the possession of any person without his consent. It is thus an offence against possession and not against ownership, as stated in illustrations J and K to section 378. The offence of theft consists in the dishonest taking of any movable property out of the possession of another without his consent. To constitute offence of theft, the following ingredients are required. Number 1, the accused must have a dishonest intention to take the property. Number 2, the property must be movable. Number 3, the property must be taken out of the possession of another person, resulting in wrongful gain to one person and wrongful loss to another. Number 4, the property must be moved in order to such taking, that is, obtaining property by deception. And number 5, taking must be without that person's consent, express or implied. Indian Penal Code does not consider wife and husband as one person, so they are liable for theft if they take anything from each other's possession without the consent. In India, under Hindu law, husband and wife can be liable to theft against each other. For instance, husband is liable for theft if he takes away the stridhan of his wife, which is her exclusive property. Likewise, if the exclusive property of one is taken away or misappropriated and marriage breaks down, the other will be liable for theft. There is no presumption that husband and wife are one for the purpose of criminal law. Similarly, under Muslim law, wife may be convicted of theft for stealing husband's property and vice versa. Moving further, let's try and understand dishonest intention. Intention is the gist of the offence. The taking will not amount to theft unless the intention with which it is taken is dishonest. If it's not taken dishonestly, it will not amount to theft. It must be taken with the intention to cause wrongful gain to one person and wrongful loss to another. In Sri Charan Chungu, if a creditor takes movable property out of debtor's possession without his consent, with the intention of coercing him to pay his debt, this constitutes theft. There can be no theft where there is no dishonesty. For example, A, in good faith, believing property belonging to B to be his own property, takes that property out of B's possession. Here, as A does not take dishonestly, as such he does not commit theft. It's clear from the definition that the gain or loss contemplated need not be a total acquisition or a total deprivation. A person snatched away some books from a boy and told him that they would be returned when he'll come to his house. It was held that the accused was guilty of theft. The question of whether the accused had a dishonest intention is one of fact. Whether a claim is bona fide is mainly a question of fact, and it's for the accused to prove that his claim is bona fide. Similarly, when a partner in a business did not know that he was endorsing a check and believed that he was merely signing a piece of paper which he gave to the accused, even though the property for which the check was endorsed did not pass to the accused by reason of endorsement, but remained with the complainant, the accused was held guilty of dishonestly appropriating property. It cannot be laid down as a general principle law that a partner can in no circumstances commit theft of the partnership property. Now let's focus our attention to movable property. The subject of theft must be movable property, that is, corporeal property of every description except land and things attached to the earth or permanently fixed to anything which is attached to the earth. Property is said to be movable when it's capable of being carried about. It is said to be immovable when it's permanently attached to the earth. The explanation 19 to section 378 explains that a property becomes movable when it's severed from the earth. A standing tree is immovable property, but it becomes movable when it's cut down. Similarly, in Krishna Reddy versus Munippa Reddy, the accused had dishonestly carried away 100 carloads of earth from the complainant's land. It was held that she was guilty of theft. In Avatar Singh versus State of Punjab, the apex court held theft of electricity is not theft of movable property within section 379 IPC. However, it's punishable under section 39 of the Indian Electricity Act 1910 as theft of energy up to 3 years of imprisonment or fine up to Rs 5,000 with a minimum of Rs 500 or with both. On the other hand, cooking gas or water passing through pipeline can be subject of theft. When the accused fixed a pipe in the main line just before the meter to avoid payment, he was held liable for theft. Idols from the temples, paintings from museums and other public or private places are subject to theft. In Ahmed, the court held that human body, whether living or dead, except mummies or dead bodies preserved in scientific institutions or medical colleges, is not subject to theft. Now, moving property in order to such taking. Theft is complete the moment a thing is moved, even though such thing may yet be far from passing into the thief's possession. Moving a thing is the initial stage in the possession of that which is taken, and theft is considered completed at such an initial stage. Thus, the actual taking or possession is not of much consequence in determining whether theft has been committed or not. What the law contemplates is the intention to take, and the actual taking is a step beyond such intention and not relevant for the purpose of definition of such theft. Now, taking need not be permanent. It's not necessary that the taking should be of a permanent character or that the accused should have derived any profit. In Pyarelal Bhargava versus State of Rajasthan, a temporary removal of an office file from the office of a chief engineer and making it available to a private person for a day or two amounts to the offence of theft. In Chandikumar Das Karmakar versus Abhenidhar Roy, the appellants were charged with committing the theft of fish by fishing in a tank called Nutan Pukar in the possession of the complainant. The appellants were shown as tenants in the records with their interest described as settled Rayat Muhirrat, while the complainant claimed to be in possession of the tank as a result of Bhag partition. Held, the appellants were not guilty. The appellant had bona fide claim, though weak, over the property. The offence of theft consists in the dishonest taking of any movable property out of the possession of another without his consent. An act does not become theft unless there be not only no legal right but no appearance or colour of a legal right. Now, taking with dishonest intention. Taking out of possession being the essential ingredient of the offence of theft, one of the ingredients of the offence of theft is intention to take dishonestly. This intention is known as animo furandi, with intent to steal. Without it, the offence of theft is not completed. A bona fide claim of right will rebut the presumption of dishonesty. A person may commit theft by dishonestly taking his own property out of possession of another. Anderton versus Wish. D took a price tag from a cheaper brush and struck it over the tag on another brush she intended to buy, which was costlier, thus intending to pay less than the true price. She paid the lower price and was arrested outside the shop. Held, allowing the prosecutor's appeal against D's acquittal, that D had assumed the rights of an owner within Section 3 of the Theft Act 1968 when she changed the price tag. She had therefore appropriated the brush and was guilty of theft at that stage. Now, without consent. The offence of theft is committed if the property of another person is taken away from him without his consent, express or implied, with the dishonest intention. In K. N. Mehra versus State of Rajasthan, court held that even a temporary retention or deprivation is enough to show that the offence has been committed. The removal of the property must be without the consent of the person in possession of it. No charge of theft can therefore lie where a creditor takes property from a debtor who subsequently finds that the debt was time-barred and he had been under no obligation to give anything to the creditor. The reason being that such taking, though no longer enforceable at law, is nevertheless with the debtor's consent. A consent obtained by force is no consent. Thus, the property must be moved without the consent of the person in possession of it. Consent may be express or implied. Now, theft under English law. Theft is an indictable offence punishable with imprisonment for 10 years under Section 7 of the Theft Act 1968. Section 1, subsection 2 Act states that a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Unlike India, theft in England consists of 4 ingredients, namely, number 1, dishonestly, number 2, appropriation, number 3, of property which is capable of being stolen belonging to another, and number 4, with intention to deprive permanently. Now, let's talk about theft and larceny. The definition of theft under the code differs from the definition of larceny under the English law. In larceny, the property in question must be owned by someone, while under the Indian law, in theft, it must be in the possession of someone. The property should be taken out of the possession of a person. Now, possession and custody. The term possession must be distinguished from custody. A man is said to be in possession of a thing when he can deal with it as the owner to the exclusion of others. The property is in his custody when he cannot deal with it as the owner, but merely keeps it for the sake of another, as in the case of a servant holding property for his master. To constitute theft, the property must be in the possession of someone and then removed from his possession. If a servant entrusted by the owner with the care of a box of ornaments dishonestly runs away with the box, he commits theft. When a person pawns his goods to another and subsequently removes them without paying the charges, the removal amounts to theft. Now, Section 379, Punishment for Theft. Whoever commits theft shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. The already mentioned section prescribes punishment for theft which may extend to imprisonment, either simple or rigorous, for a period of 3 years, or fine, or with both. Now let's talk about extortion. The offence of extortion is defined by Section 383 of IPC as whoever intentionally puts any person in fear of any injury to that person or to any other, and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security, or anything signed or sealed which may be converted into a valuable security, commit extortion. Here are some illustrations. A threatens to publish a defamatory libel concerning Z unless Z gives him money. He thus induces Z to give him money. A has committed extortion. B, A threatens Z that he will keep Z's child in wrongful confinement unless Z will sign and deliver to A a promissory note binding Z to pay certain monies to A. Z signs and delivers the note. A has committed extortion. C, A threatens to send clubmen to plow up Z's field unless Z will sign and deliver to B a bond binding Z under a penalty to deliver certain produce to B, and thereby induces Z to sign and deliver the bond. A has committed extortion. D, A, by putting Z in fear of grievous hurt, dishonestly induces Z to sign or affix his seal to a blank paper and deliver it to A. Z signs and delivers the paper to A. Here, as the paper so signed may be converted into a valuable security, A has committed extortion. The essential ingredients of extortion are: number 1, intentionally putting a person in fear of injury to himself or another. 2, dishonestly inducing the person so put in fear to deliver to any person property or valuable security. Now, putting a person in fear of injury. The essence of offence is to put a person in fear of injury and compel him to hand over the property to him. The court in Reg versus George Walton and Joseph Ogden said that the fear of injury must be of a real nature so as to unsettle the mind of the man upon whom it is exercised in such a way that the act does not remain voluntary. The injury that a person may be put in fear of is not necessarily physical injury. Injury to the character may also be an injury. Where some persons used force and others received the property, all would be guilty of extortion. The court in Queen versus Mobaruk held that the threat of criminal charge, whether true or false, may amount to extortion. A threat to expose a bishop of his illegal relation with a woman was held to be extortion. But mere threat at large that divine displeasure will fall upon a person if debt is not paid does not fall with sections 383, 385 and 508 IPC 4. Now, dishonest inducement to deliver property or valuable security. A threat to use the process of law for the purpose of blackmailing is criminal, and when property or a document is obtained by threats for the purpose, the offence of extortion is committed. A village headman finding certain persons setting cocks to fight, a fight between fully male-grown chicken near a public road, threatened them with a prosecution and subsequently took money as a consideration for not prosecuting them, held the offence fell under this section. Delivery of property by the person put in fear is the essence of the offence under this section. In other words, to constitute the offence of extortion, there must be fear and delivery of property. Mere forcible taking of a thumb impression does not amount to extortion. Property under this section means both movable and immovable property. Now let's discuss the offence of robbery. The robbery is aggravated form of either theft or of extortion. Section 390 IPC defines robbery as: when theft is robbery if or in order to the committing of the theft or in committing the theft or in carrying away or attempting to carry away property obtained by the theft, the offender for that end voluntarily causes or attempts to cause to any person death or hurt or wrongful restraint, or fear of instant death or of instant hurt or of instant wrongful restraint. When extortion is robbery. Extortion is robbery if the offender at the time of committing the extortion is in the presence of the person put in fear and commits the extortion by putting that person in fear of instant death, of instant hurt, or of instant wrongful restraint to that person or to some other person, and by so putting in fear induces the person so put in fear then and there to deliver up the thing extorted. Here's an explanation. The offender is said to be present if he is sufficiently near to put the other person in fear of instant death, of instant hurt, or of instant wrongful restraint. Some illustrations are presented. A holds Z down and fraudulently takes Z's money and jewels from Z's clothes without Z's consent. Here A has committed theft, and in order to the committing of that theft has voluntarily caused wrongful restraint to Z. A has therefore committed robbery. B. A meets Z on the high roads, shows a pistol and demands Z's purse. Z in consequence surrenders his purse. Here A has extorted the purse from Z by putting him in fear of instant hurt, and being at the time of committing the extortion in his presence, A has therefore committed robbery. C. A meets Z and Z's child on the high road. A takes the child and threatens to fling it down a precipice unless Z delivers his purse. Z in consequence delivers his purse. Here A has extorted the purse from Z by causing Z to be in fear of instant hurt to the child who is there present. A has therefore committed robbery on Z. Let's move further and understand the meaning of robbery. Robbery in common language means to deprive a person of his or her property. The chief distinguishing element in robbery, theft and extortion is the presence of imminent fear of violence. In all robbery, there is either theft or extortion. The essence of the offence of robbery is that the offender, for committing theft or for carrying away or attempting to carry away the looted property, voluntarily causes or attempts to cause death or hurt or wrongful restraint. A snatched the watch of C. B stopped the victim in order to enable A to carry away the watch. As the hurt caused by B had relation to the theft of the watch, the offence was held to be covered by this section. Where one accused stopped the complainant to enable the other accused to take away the complainant's watch, it was held that the offence fell under this section. Now, punishment for robbery. Section 392 of IPC prescribes the punishment for robbery, which may extend to 10 years of rigorous imprisonment and also fine. When robbery is committed on a highway between sunset and sunrise, the punishment may extend to 14 years. When murder and robbery are committed in the course of the same transaction by the same persons, the offence would fall under this section. A conviction under this section will take place when theft is committed and injuries are caused. Now, dacoity. Dacoity is explained in section 391 IPC. Section 391 reads as, when 5 or more persons conjointly commit or attempt to commit a robbery, or where the whole number of persons conjointly committing or attempting to commit a robbery and persons present and aiding such commission or attempt amount to 5 or more, every person so committing, attempting or aiding is said to commit dacoity. A robbery is dacoity if the persons committing robbery are 5 or more in number. In Malaysia and Singapore, dacoity is termed as gang robbery. The offence of dacoity consists in the cooperation of 5 or more persons to commit or attempt to commit robbery. It's necessary that all the persons should share the common intention of committing robbery. In Shyam Bihari versus State of Uttar Pradesh, court observed that on a plain reading of section 391 IPC, it would appear that in order that a dacoity can be said to have been committed, it's necessary that 5 or more persons conjointly commit a robbery or attempt to commit a robbery. If a robbery was committed, the dacoits would have the booty with them. But if the matter rested only with an attempt to commit a robbery, there would be no question of the dacoits having any booty with them. Emperor versus Ramchand. In the case of dacoity, the circumstances that the inmates of the house, seeing the large number of dacoits, offer no resistance and no force or violence is required or used by dacoits does not reduce the dacoity to theft. In Lakshman Ram versus State of Orissa, the accused persons who committed dacoity in the houses of the complainant one after another were held liable under section 395 for committing dacoity. The ingredients of dacoity are A. The accused commit or attempt to commit robbery. B. Persons committing or attempting to commit robbery and persons present and aiding must not be less than 5. C. All such persons should act conjointly. The word conjointly refers to united or concerted action of 5 or more persons participating in the act of committing the offence. Lakshman Ram versus State of Orissa, in the case of recovery of stolen property at the instance of the accused, just after the occurrence, the accused are liable to be convicted not only for dishonestly receiving property stolen in the commission of a dacoity under section 412 IPC, but also under section 391 IPC with the aid of section 114 Evidence Act. All the accused persons committed dacoity in the houses of the complainants one after the other and looted and took away various kinds of property in the nature of watches, ornaments, etc. Held or the accused were guilty under this section. Now, punishment for dacoity. Section 395 IPC prescribes the punishment for dacoity, which may be either imprisonment for life or rigorous imprisonment up to 10 years and fine. The Supreme Court in Kushu Mohtan versus State of Bihar held that the accused, while carrying away stolen property, exploded crackers to frighten the persons who wanted to pursue them. Held, conviction under section 395 IPC is proper. Where there is evidence that 5 or more persons were connected with the commission of dacoity, all such persons would be guilty of the offence under this section. Friends, that was all about offences against property. Thank you very much.